Okay, welcome everyone. This is the Saturday continuation of the Friday meeting of the Committee of Bar Examiners. I'm the chair, Paul Kramer. We have, just so you know, we have two items this morning, one being the American Heritage University hearing, and then the last item is one we didn't get to yesterday, and that's the review of the BRC status and instructions to our, providing instructions and feedback to our representatives on that body. And then this afternoon, we will be in closed session to choose questions for the upcoming bar exam. That'll be just the attorney members. The public members will, at that point, have an opportunity to go do whatever else they would like to do. So please take the roll.
Dr. Bolton, Robert Brody,
Yeah, present.
Dr. Cow,
Here.
Alex Chan,
Present.
Jim Efting,
Here.
Kareem Gangora,
Present.
Judge Guerra,
Here.
Dolores Heisinger,
Here.
Judge Herman,
Here.
Larry Kaplan, Alex Lawrence,
Here.
Esther Lynn, Bethany Peak,
Here.
Ashley Silva Guzman,
Here.
Vince Reyes,
Here.
David Torres, Dr. Wilcoxon, and Paul Kramer.
Here.
We have a quorum.
Okay, thank you. Our first item then is 04, I think it's 401. Is that right, Natalie? American
That's
Heritage
correct.
University School of Law. And are you or Mr. Efting going to introduce this?
I think that I may, given current events. Okay. Good morning, everyone, and welcome back. We're here to discuss the committee's decision regarding whether to place American Heritage University School of Law on probation or to close the school based on its compliance status. Since we were last together and since you read the staff memorandum, there has been another development. Last evening after 5, the school did contact me via email and advised that it planned to relinquish its registration voluntarily. And I'm going to ask if we could just show their email, just so that the committee can see that this was the school's voluntary choice. So first and most clearly, they indicated that they withdraw their request for a hearing. A hearing will not be held this morning. And let's see, I'm going to turn the mic with me. Can everyone see, or shall I read out their questions? And Audrey, let's go down to the bottom. Here we go. So this email is from Dean Mosley. She is the dean of the law school, and she's writing on behalf of herself and the chancellor of the university, Dr. Tony Ojamian. Dear Natalie, Dean Mosley writes, the Chancellor, Dr. Tony Ojamian, has requested that I send you this email to forward to the committee. Dear ladies and gentlemen of the committee, first we would like to thank you for all of your efforts and questions to date. We started working with you in 2009, and we have undergone a lot of changes and requests to date. Before we started the meeting on December 3, 2022, we wanted to announce that effective immediately, we wish to withdraw or relinquish the registration of the law school. We have evaluated the implications of this, and our key focus will now be making sure our remaining students complete their education without any disruption. We expect the Bar Committee to let us know the next steps for a teach-out plan for students. Sincerely, Rosa M. Mosley. Upon receiving that communication, I sent some questions for clarification. First, to confirm that they did not plan to attend a hearing today. They indicated that that was the case. And then additionally, to get an understanding of how many students they were enrolling at this time and what they meant when they talked about having the students complete without disruption. So if we scroll up one more, we'll see their response. So at the time of their annual report, which was September 15, they enrolled 31 students. According to this email, they're currently enrolling 13 students. This school has a one course at a time schedule. And so rather than having a full semester with several classes, they teach one course at a time, and that's not unusual. Their current course will end on the 14th of January. And here, regarding whether they want to do the teach out themselves or effectuate an orderly transition, they say they'll respond at a later date. But given the posture of the students, the committee may wish to make arrangements if the school is not so prepared or doesn't advocate a particular choice today. I did advise them this morning that the committee would proceed with its portion of the notice motion, and that if they wanted to make public comment as to a teach-out plan or any other topic, they could do so. And just to confirm for the record, I'll ask Devin to let us know if there are any raised hands for public comment from the school.
So Paul and Natalie, just to confirm, what this will mean is that we are withdrawing the hearing from the agenda, but we'll proceed with the action that is on the agenda.
That's what I'm hearing, yes. Do you disagree, Natalie?
I agree. And Devin, are there any raised hands for public comment from the school?
We do not have any raised hands.
Okay, thank you. So at this time, I would propose that we would go to the PowerPoint just to remind the committee of the posture. The purpose of this exercise would be to help the committee determine, presumably, the closure selection and the terms of the closure to give clarity to the school and the students. And I appreciate your patience. We obviously are adapting this to reflect the current circumstances which happened last evening and also in the morning today. Okay, next slide. So in August, the committee noticed to the school that you intended to choose probation or closure of the school today. Next slide. Just briefly, this is summarizing what we saw in the email that yesterday the school withdrew the request for the hearing and gave some information that will help the committee to create an orderly closure plan. Next slide. The school is familiar with the non-compliance process. They would have known the steps and the options and would have had the opportunity to plan ahead for any choices that were best for the school based on their issuance of a prior notice of non-compliance in 2015. That notice did go all the way through to this point. And after the non-compliance inspection, they did cure the defects at that time, and they went on to continued operations. They responded timely. They responded responsively. So this is something they are familiar with. So when you see them make different choices this time, this same leadership does know how to respond to the requests of the committee and on time. Next slide. So regarding this current notice, the road to this notice began in 2020. The school has the first opportunity to establish their compliance with the self-study, which is a written document. During the time they're creating that self-study, they can consult the State Bar, and many schools often do. The State Bar will even begin to work with a school prior to the inspection if there are any concerns noticed in the self-study. The school was offered 2 chances to put this together. The first self-study was an undifferentiated list of information. We gave them an additional 3 months to create something more orderly. Went to and through the inspection. The resulting inspection had approximately 30 recommendations. The school had an opportunity to comment. They provided a response to the recommendation. Both the inspection report and the response were provided to the committee. Next slide. After the committee reviewed, the committee issued a warning letter to the school and asked that the school respond. The school did provide a response. This committee reviewed that response, and after reviewing that response, determined it was unsatisfactory and issued a notice of noncompliance to the law school. The law school was directed to respond, but the law school did not provide a response. Approximately 2 months later, in June, when the committee was ready to determine as to how to proceed based on the non-response, the school did provide a written document of their current status without any evidentiary support. So it can't be termed a response, but it was a written document. That document is attached today as attachment A. That was provided approximately 1 hour after the committee meeting started, and so the committee did not have full time to digest. The school was advised that anything in the document could be discussed during the non-compliance inspection that the committee ordered. The non-compliance inspection was held on July 12th. The school was allowed to extend the time, and the school confirmed that they had shared all that they intended to share at that meeting. One of the outstanding issues along the way has been the status of the ownership of the school in the wake of a potentially failed purchase. Today you have attached to your agenda item and a letter dated August 12th from their attorney indicating that the purchase status is unclear. In August, the committee reviewed the materials and the response, inspection response, and determined that it would be appropriate to notice the school that probation or closure may be appropriate. On September 6th, the school requested a hearing. The hearing was scheduled for this morning. Throughout this period, staff has remained available to the school. The school has specifically complimented staff verbally and in writing, not just myself, but all of the staff with whom they interacted in terms of the timeliness and the helpfulness of the responses, yet many of the documents were not received. Earlier this week, after the staff memorandum was posted, the school did provide one of the documents requested, which is a major change. Staff requested additional support because it was more of a cover letter without the details required under the rules. The school did provide some, but not all of the information requested, and staff handled this in the manner it would with any other school. We proceeded to prepare for this hearing and received the communication that you saw last night. So these are the documents before the committee as you begin to open your deliberations, which seem to be, in this case, how to proceed for an orderly closure of the school. Staff will now provide a revised motion that could fit the circumstances here. And the things that you'll be thinking about are the facts to date, the additional information you received last night, that you have your own noticed action, so you are fully authorized to take action today and to provide certainty and an orderly closure for the students. Just to remind you, I mentioned earlier what the student profile was. So as of the annual report date, 12 1Ls, 13 2Ls, 2 3Ls, 4 4Ls. As of last night, the school advised that they had approximately 13 active students. I asked them to tell me their grades 1, 2, 3, 4, but they did not provide that at that time. So that's an idea of the student population. And in the past, when schools have had to close, potentially even on short notice, we've worked with the students and we've worked with other schools to help them find other placements if they plan to do so. And just a reminder, they're on a one course at a time schedule. This may be unfamiliar to some of you, but several of the schools use this successfully. They are teaching a course that will end January 14. Okay, so we can turn over to the motion. And the motion, normally we provide you a completed motion, but here there are a couple of decision points to be made if this motion is something that is supported. Sorry, thank you. Okay, so if the committee is considering a disclosure and a closure, one of the things that's challenging is that under the applicable rule, the committee must determine a closure date, and then as of the closure date, the school loses its degree granting authority. So an initial thought was to suggest an immediate closure, which is exactly what they request, but permission to teach through the 14th. But the rule doesn't seem to support that, and we don't have commitment from the school that they plan to teach. So the date will become important. The school has asked for a date of today. This will cut the semester for the students in the middle of the semester, but this may be all that the school intended to offer to begin with. So this may be a good point to open the discussion.
Any thoughts? Bethany?
Oh,
It's a question regarding what you were just talking about. So if we make the date today, what happens to the students?
So at this point, they're in the middle of their semester. I believe it's a Wills and Trusts class, and so their education will end mid-semester. Another alternative would be to choose January 14, and if the school is willing to teach, it would allow them to get through that course in this semester and then to transfer. For most of the students, that means they would transfer and do a spring or summer start, perhaps a fall start if they wanted to wait.
Cream?
yeah, Natalie kind of answered my question, but what authority do we have to ensure they teach out?
Well, here the issue is partially as well, what resources will the school commit? And here, the school says that they do want an orderly education without disruption, but in a direct response to the school hasn't committed any resources. So the school has not indicated that they will teach at all.
David?
One, we can't compel the school to complete out. Secondly, there's a very good, well, at least a 50% chance that the students are going to lose this semester.
Well, is that clear?
That's what I need to clarify. Is that correct?
It's possible. There is more of a chance that if they can complete this portion, that they'll be able to retain a half a semester.
So perhaps that it might be best if we terminate effective sometime in January after the course is to be completed. Wouldn't that be in the best interest of the students?
I think that has the best opportunity. We had very little time to prepare. We couldn't do an hours count to check, but they begin their semesters usually September 25th, so there is a good possibility that they may have enough hours if they can complete their study till the 14th, and the school is willing to do that teaching.
So then they have those credits that they can take to another school.
They may have credits, or if they're in their first year, we would need to work with a transferring school to establish their eligibility for the first year law students exams, so they might claim them in the future.
Okay, Ashley?
Would the January date be inclusive of grading for that course, or if we cut it too close to the end of the course, would that then end the school's ability to finish up the grading and the giving of the grades?
It's quite likely that if set up correctly, you could have them do an expedited grading process on that date. The challenge becomes if you give a period of time in this posture, then it's unclear how that time would be used.
But we put it in terms of degree granting authority. So is anybody likely to be getting a degree in January? That's mid-year, right?
It should be unlikely, and because this is a registered school, Even if the school were to simply issue degrees upon closure, they would still have to comply with the hours requirement.
Right. So is it the consensus of the group that we should try to make it possible for the students to complete this, this course, this semester? Because I see the school's emails ambiguous. They say withdraw, but then they say they want to, it sounds like they want to have a teach out, and they may even want to try to somehow get their 1Ls out of their program. And that's, you know, given the status of their compliance, that's way beyond the pale, in my opinion. But so it sounds like, and so if nobody's going to get diplomas, the grading, I don't think the date affects the grading, does it? They can issue grades after we've terminated their degree granting authority.
Unless OGC has any other concerns.
Or maybe we just need to be clearer and maybe not describe the deadline solely in terms of degree granting authority.
As a practical matter, when you think about the grading process, remember that it's a maximum of approximately 13 students to do the grading for. So it is completely reasonable that they could take their exams during the day and have them graded even that evening on that date.
What would you recommend as a date?
I would recommend for clarity the conclusion of classes, the 14th. Or if you wanted to give a little bit of extra room for any grading administration, perhaps later in that month, but prior to this committee's meeting in January to confirm that complete closure.
I think we meet at the end of the month, as I recall.
I believe it's the 27th. Audrey, is that correct? Yes? Thanks. So
It is unfortunate that they haven't come to answer some of our questions and perhaps explain what they want so we could, if it's appropriate, help them more, but that's their choice.
it's also not inconsistent with the school's past pattern.
May I?
Natalie. Sorry, Natalie, this is Alex. Can I ask you a quick question? Did they accept anyone else this past summer or this past fall semester?
According to their annual report, yes, I believe it was 13. But I tried to get updated information for you for this morning. There seems to be a steep drop-off between their enrollment in September and now.
When you say drop off, what do you mean by that? If there are 13 students that applied and registered for the school in the fall, are you saying those 13 students were no longer registered with the school?
It seems so. As of September 15, they reported 31 as their enrollment, but currently they report approximately 13 in total across all 4 grades.
And for the 1Ls, I'm concerned because assuming they paid the tuition for the full year, is there any plan to refund their tuition for the rest of the year?
That's part of what we can look at. I believe they pay their tuition in 2 installments, so it's quite likely that they have not yet paid their tuition for the year, but that's something I would need to confirm.
I would appreciate that. And certainly, Chair, let the record reflect that this is a classic example of what harming students looks like. By requesting the degree granting authority be terminated immediately, it seems to me, at least to me, that the school has no incentive to teach out the rest of the semester, which really puts the students in limbo. And so right now, really our priority is make sure the students are protected. I care less about what the school itself is going to do. I'm more concerned about how we're going to be able to help the students transfer to other schools and continue their education and finish in a timely manner. So, so with that, you know, if we, I certainly believe that we need to extend the time and to give the school an opportunity, and hopefully they would hear about our comments and feedback that they would teach out the rest of the semester, so that the students are not going to be, well, one, they would be able to get their grades and be able to take some sort of exam that warrant a grade on the transcript. I think this is important, right? Am I correct, Natalie? If somehow they stop teaching today, they will not receive a grade for this semester for their classes?
If they stop teaching today, I would expect they would not receive a grade. Another piece to weigh in this calculus, Alex, would be the students' performance on the state bar exams. And there's a section of the staff memo that talks about it. I don't remember without double checking, but this school for a number of years now has graduated almost no students, had almost no students pass the first year law students exam, and had almost no students pass the bar exam. Therefore, continuing to teach at this school rather than helping them to transfer to another school that may allow them a more reasonable opportunity to pass those exams could be more protective.
I defer to the group, but I do believe that at least the students would have to have a grade. Otherwise, my concern is once they transfer out, they would have to retake those classes again simply for the fact that they haven't received a grade. And so I would think any school would require them to retake the course, and that would prolong their education.
Well, we can only do so much, and we seem to be settling on a date in January that would allow them to complete this class.
Well,
Larry, I think you had
yeah.
your hand up, and then David.
Yeah, I just wanted to, do we need a motion or something? Because all I could say to what Alex said was amen, you know? So I don't know, do we make a motion or something to?
Well, by Rosenberg's rules, we're late because we should have had that before the discussion, but
No, we did.
we're going to ease into that behavior.
So,
David, and then Dolores, and then if there's no more discussion, we can.
so there will be a motion to,
There will be, yes.
and we can incorporate the sentiments that we heard from Alex about how what's key to us is taking care of the students.
Yeah, David.
If I may I, again, Natalie, ask, number one, if we were to go to January 20th, which I believe is a Friday, that would give at least, I'm hoping that these students are allowed to complete the classes and we get their grades. But secondly, again, in line with what Alex said, how can we place in this motion something where we learn, or we can compel them to ensure some type of fairness with respect to tuition, or ensure that these students are not going to lose that tuition that they paid into this semester?
We can certainly look with OGC to what refund possibilities may be available for services that are not delivered, yes.
And if that's the case, that would be separate and apart from this particular motion, is that?
Well, we don't have the authority to order them to do it or to enforce such an order.
Which is why I'm asking, so.
Yeah, I don't think.
Then my recommendation, I was about to call you your honor. My recommendation would be to ask for January 20th, and I guess apart from this would be to, well, I move that the motion that is presented up on the screen, I'm going to make that particular motion, but apart from that, well, I'll make a friendly notation afterwards, but go ahead.
Dolores?
I don't think this happens very often, Natalie. But I think it might be informative for the committee, with your experience, expertise, to give us a thumbnail sketch of what you think happened with this school. And beyond that, what should we as a committee learn from this experience?
Okay. So previously, the school had a particular leadership team. That leadership team left the school and started their own school. At that point, the school needed to make a change. It lost its entire leadership team, and at that time, I want to say it might have had about 90 students, and many of those students followed the leadership team. The school considered several choices and planned to do a purchase. Ultimately, you saw from the staff memorandum, there were a lot of issues related to that purchase, and it resulted in a lot of limbo for the school, and I think that is part of how we got here. One thing that you already see in the staff recommendations right now is that when schools request a transition of any kind, we ask many more questions as staff and provide more information to you in terms of why is it happening, when is it happening, what does completion look like, when is your scheduled completion, and will you affirmatively apply, inform the committee if this changes. So I think that's really important in the future. And without them confirming what happened to their own purchase, perhaps that diffused their efforts and got them to this point.
Do we know how many students will be impacted?
We think, they tell us approximately 13. Now, something else to consider in this matter is the point made by David and Alex is well taken to allow the students to complete this course. But at the same time, when they transfer, the transferring school does not need to provide credit for the courses they've already taken. And given the performance of this school on state bar exams, while it does make sense to give the students a chance to finish this course, it may be that the receiving school may not, and effectuating a transfer to a new school after the conclusion of this semester is likely the most protective for these students.
Let me just, somebody else want to say something?
Yeah, I had a question. Just looking over the materials, they seem to be in chaos financially. If we plan on having them teach this out until January, can they actually pay an instructor to do this? What would be the motivation for an instructor if they can't get paid?
It's possible that they may not, and in that case, then we would work with the school if we can, and we would work with the students so long as they're registered with the state bar to help them find a placement.
Okay.
Okay, I want to just note one thing. In the second further move paragraph, the phrase is terminated effective January 2023. Shouldn't that be at the end so it applies both to the degree granting authority and the authority to teach?
I think that that is a good idea.
Oh, I didn't see they also terminated originally, but
That's okay. Your way is better, Paul.
And then there will be a surviving university which has a business program. So when it says the custodian will be American Heritage University, that's who, and they're co-located in Rancho Cucamonga with the law school.
With that edit to the motion, you took out the word authority after degree granting. I think you need to put that back.
I'm sorry, who was that?
Donna.
Donna. Oh, Donna's voice is, can you adjust the levels on the Zoom?
Is offering helpful information.
Yeah, I couldn't quite make out what you were saying, Donna, if you could repeat yourself.
Yeah, I apologize. I was just saying that in that motion, when we edited the motion to move the date of termination to the end, we had inadvertently taken out the word authority after degree granting. So Natalie just added that back in.
Oh, okay, thanks. Does somebody want to make this motion or an alternative motion?
Second.
So
Okay,
moved, Torres.
and
Second,
Gongora second?
Yep.
No further discussion, I guess, so let's take
Just
the vote.
real quickly, if I may, Mr. Chair, Natalie, so I guess from, I mean, how do we not become the villain in this on the student side? Do the students have the ability to go to American Heritage and get their money back, or like I'm thinking of all the worst case scenarios here.
Well, we certainly would work with them. We certainly would see what remedies, if any, are available under the rules. They have their remedies under contract as well. We've had quick closures before, and we have worked with the students who wanted to transfer. Some did not continue with their education, and they've been satisfied.
Yeah.
And here, giving them an opportunity to attend a school where they can pass a state bar exam and they can become licensed is the best way to help them.
And do we know if those students are in the state of California, or, because I know they're like a global brand?
We don't, and that's part of what we'll be researching.
Okay.
And
Because I noticed
so-
it's in Rancho Cucamonga, and I'm like, I've never heard of this school, but, you know, I just hope we could follow through and make sure that the students are taken care of as much as we can.
We always do, and one of the first things that I will do as a staff member on Monday is to reach out to everyone that's listed as a current student registered with the school to communicate with them immediately.
And Kareem and members of the committee, I will just note, and Natalie can confirm the timing on this, but because the committee issued a notice of noncompliance earlier this year, that was required to be posted and disclosed to students. So that does currently appear on their website, and that should have predated anybody who enrolled in September of this year. So the notice was out there prior to any enrollments that happened in September.
It's unclear that it was posted quite as early as we would have liked, but it is clear that they updated their materials and issued it to students, so students would be aware.
Let's see, Larry and then Larry David.
So the, this motion says nothing about helping the students out. Is that because we don't have the authority, or?
Well, it is something staff normally does, so I don't know if you need to direct them to do that. You could ask staff to do that. It's,
Regardless of whether it's in the motion, we will be doing it. But it is something that could be placed in there.
I'm just thinking, yes, staff does it, but maybe it's important for us to express the fact that this committee is here for more than just regulating law schools, but also for, supporting law students. It's
Larry?
almost like kind of like an expression rather than a direction to staff.
So one possibility is to say, further moved that staff is directed to take all reasonable steps to assist the law students to complete their legal education.
Yeah, something like that, yeah.
I'll accept that friendly amendment, John. Paul? Mr. Chair.
I'll accept that friendly second.
Oh, yeah, further move that staff is directed to take all reasonable steps to assist the law school students in transferring or pursuing their legal education if they so choose.
Yeah, that's nice. Perfect.
okay.
May I make just a suggestion to avoid issues in the future, which might be to assist the law students in evaluating their options for pursuing their legal education?
Excellent.
And then if they so choose, probably can come away if
out.
that's in there.
This also supports Ashley's point from yesterday. This is something that you know and that we know as staff, but stating it this way is something that students can see.
That's right, they're gonna read this. So we want to communicate to them that, we care about them, that thing with Alex.
I'm sorry, can you please speak into the microphone? We can't hear you on Zoom.
No, I think you know, that's important because the audience for this is the students. They're going to read this. And as Alex said earlier, you know, we kind of don't care about the school. That's their problem. But we care about the students. And that's what that says.
Dr. Cal?
Oh, sorry.
Sorry, Nellie, can I ask you a procedural question? So if we are not sure if the students are in state, then what authority do we have if these students are learning online out of state?
You have jurisdiction over the school, and I certainly will defer to OGC here. And so what you're focused on is the operation of the law school, but what action we normally take as staff is to contact those students that were in a school regulated by the committee to advise them of their options.
So if I can ask an additional question, so is the school's motto remote learning, or is it in person, or is it a hybrid?
It's 100% distance learning, and fortunately at this time, if the students are evaluating their options, they may have other, not only unaccredited, but also accredited distance options to choose. So even if they're out of state, but they want to pursue a California license, they can do so through other distance programs if admitted to those programs.
Did somebody else have Dolores and then Korean?
Just a quick question. So I think we read that this school affiliated with American Heritage University at some point, not too long ago, I don't think. Does that organization, American Heritage University, bear any responsibility in any of this, financially or otherwise, to help the school if they are in financial chaos to help teach out the students?
It would be hoped so, but in part, that's part of the lack of clarity regarding the ownership situation. But yes, it would be hoped so. And they will be the custodian.
Though I would believe it is very unlikely, just given that the two schools are likely incorporated separately from each other. I would be hard pressed to believe they're one, single entity. And so, liabilities for one entity will likely not be imputed to a different school.
And Alex, you're probably correct, because at this point there are actually two corporate registrations for the school, one in the name of the purchaser and then one in the name of American Heritage University filed this spring. And so if this is the school's method of operation, that's something to be considered as well, because there doesn't seem to be that joint cooperation to protect the students.
But that's all a matter for potential litigation down the road, and it's not within our power to undertake that litigation on behalf of the students or to advise them. And our leverage is their license or their permit from us, and they've given it up. Cream.
Yes. Dang, goes in my head. I had something regarding oh my gosh, it was not teaching out. There was something else that I wanted to get clarity on. Can you come back to me, or does nobody else have questions?
We might be getting close to a vote, but any other questions?
Oh, now I remember. So on their website, there's no disclosure. So I know, like, I'm on it right now, and I don't see nothing about they've been issued non-compliance.
It's their 4.241 disclosure.
Yeah.
It's an additional disclosure that the students get before they pay.
Okay.
And it's listed on there.
Okay.
What's on their website is their BMP code 6061 disclosure, which doesn't include that, but a suggestion that may come from this procedure is to add it there as well.
Okay.
Kareem, if you actually go to their important disclosures site, I'm on it right now, and you scroll way down, it discloses their 2015 notice of noncompliance and their March 2022 notice of noncompliance. It's about 3/4 of the way down the page.
Yeah, and that important disclosure is at the very bottom of the page.
Yes.
So it's one of those, hidden things. My only thing is, what do we do as from our communication standpoint? Do we say anything that the school's been withdrawn? Because I know when we have a lawyer that's been, have their license taken away, that's posted publicly and shared throughout. Is there anything that we do in regard to that?
We do, we post that on the list of law schools, and that would go up next week.
Okay, awesome. Those are all my questions. Thank you.
Dr. Cal?
Natalie, I have an additional question. From precedent status, what similar situation have we had with schools that terminate immediately, like in this situation?
We have had other schools that have done so. One such school was Lady Justice School of Law, and when they closed at the conclusion of a semester, but about a week prior to the next semester, they determined they didn't have the funds to operate. We reached out to the students that had planned to enroll. We helped them to evaluate their legal options, and the vast majority of them decided to continue and did transfer.
So from a precedent status, we haven't had a school that has acted in this manner where they are asking to terminate in mid-semester then?
This is extremely unusual.
Well, we did have that school recently that basically just disappeared on us in San Francisco, and we had to go through, I think, 4 or 5 separate meetings to finish the process of terminating its status.
They also cut off communication at the end of a semester. They did not do it mid-semester. This is extremely unusual.
Okay, any more discussion before we vote? Again, the motion is on the screen. Is that shows all the paragraphs? Yep. Okay, let's take the vote then.
Dr. Bolton? Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora?
Yes.
Judge Guerra?
Yes.
Dolores Heisinger?
Yes.
Judge Herman?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Bethany Peak?
Yes.
Ashley Silva Guzman?
Yes.
Vince Reyes?
Yes.
David Torres?
Yes.
Dr. Wilcoxon? And Paul Kramer.
Yes.
The motion passes.
Okay, so then our final item for the open session is, it's related to the BRC, and it's 0200, I believe, is that correct? Let me get my script here. Wrong one. 0200. So the discussion of the Blue Ribbon Commission on the future of the bar exam recommendations and next steps. Esther Lynn and Alex Chan are our representatives on that commission. I don't think Esther is with us. At least she's, nope. So Alex, I'm willing to help you with the discussion if you need it, but you want to start?
She was going to be taking the lead, so I wasn't really certain what she wanted to talk about. But perhaps I think, Audrey, if you can give me a hand just to summarize the what happened last meeting with the motions with respect to the out-of-state and foreign attorneys for the group, please.
Sure. At the last meeting of the Blue Ribbon Commission, Amy gave a very detailed presentation about other states and what they do for reciprocity and comity in admitting attorneys into practice. So after that presentation and conversation, the Blue Ribbon Commission recommended that the Supreme Court revise the requirements for licensed out-of-state attorneys to be admitted to California without sitting for the California bar exam. And in the exploration of this, asking the court to explore the minimum number of years of recent practice in another state to establish minimum competence. So they didn't move forward a recommended number of years of practice, but that be explored. And then they further recommended that the Supreme Court defer the decision to modify the admissions requirements for foreign attorneys and foreign educated applicants until the new California bar exam has been implemented. So they did not move forward a recommendation regarding foreign educated or foreign attorneys, just for U.S. Barred attorneys. There was sort of a procedural motion also at the last meeting about how to get from the recommendation to develop a California-specific exam to the actual development, which is that if the Supreme Court adopts the Blue Ribbon Commission's recommendation to develop a California-specific exam, the State Bar, in consultation with subject matter experts in exam development, will be tasked to design that exam. So it's just sort of procedurally, if this, then this. So if the Supreme Court says yes to a California-specific exam, then the State Bar will be directed to design that exam. That is basically a summary. We did not go into any more discussion really about a bar exam alternative at the last Blue Ribbon Commission. And the next step would be, as we discussed yesterday, creating the report, summarizing all the meetings, all the motions and recommendations, and then Chair, your discussion on how the Committee of Bar Examiners might want to append something to that report.
Okay, so for the benefit of our two new members, there was also earlier, before this last meeting, they made decisions about the nature of a future bar exam, California specific bar exam, decided not to use, for instance, the uniform bar exam, and also they were deadlocked on whether a alternative to a bar exam should be created. They could not pass a motion to say, nope, don't do that at all, or a motion to say, here's what it should look like. And so where we are is, do you want to speak to this, Alex? Or are you willing to let me just take a stab at it?
Go for it, Chair.
Okay. So where we are is, as Audrey mentioned, the commission is going to put out a draft report probably in January before, or they'll vote on it before our meeting, and it would go out for public comment. So one of the things Alex and Esther and I had been talking with staff, including Donna, about was how our group opinion could be conveyed in that process. And one idea is we could just make a public comment during that comment period, draft something, we could approve it here, maybe at our January meeting, and send it out. But that's kind of awkward to have one bar entity making public comments in another's process. And Donna pointed out that we have the opportunity, because we have two members on the committee, to have them write, I'm not sure what the proper term for it is, but something like a concurring or dissenting opinion that could be attached to that document, either when it goes out for public comment or at the end after the commission reviews the public comment and issues their final report. And so in order to set up Esther and Alex to be able to do that, they need to hear from us. And we were thinking about doing it at the October meeting, but then our agenda really got very long on us, and also it was pretty clear that the commission wasn't going to do anything major at their next meeting, and so we could delay that discussion till today. But I think it's really important that we have that. I appreciate that Esther and Alex are willing and seeking our input, and so the purpose of today's discussion is to do that, not necessarily to pass any particular motion, but to give them a sense of what the consensus of our group is, if there is one, so they can take that back. And we have to leave it up to them to decide if it's appropriate to append our thoughts to the draft as it goes out, or to the final report. But we wanted them to be ready, because if other people are doing that same thing to the draft, then we want to be able to do that on our behalf as well. Let's start with questions that you have to flesh further, sort of flesh out your own understanding of what's going on here. And then we'll talk about, what your thoughts are that we want to send back to Alex and Esther. David?
If we're talking about a California-oriented examination, and knowing our relationship with the NCBE, would that possibly consider developing a written examination or some type of multiple choice that is corrected within the state of California and eliminating the NCBE as an examination source? And again, the other one would be whether or not this examination would be a 2-day examination as we've recently changed.
I can answer that. One thing that I think everybody needs to understand is that, so California's, the BRC looked and explored at what the plans are around the state. So one of the questions, or around the country, one of the questions that was posed to the BRC is, should we adopt the new version of the UBE? So there are already plans underway by the National Conference of Bar Examiners to modify their exam, and they have been creating what they're calling the next generation exam, which is a new version of the UBE that's no longer going to have the same format that exists now, that is essays, PT, and a multiple choice section. They're going to morph their exam into something that is more of a reduce the use of multiple choice. Again, they're targeting the reduction or the elimination of high memorization in the exam. So they'll have something like vignettes and PT-styled questions. And so that's happening there on a 5-year cycle that's about to be introduced in, I believe, for the July 2024 exam. Some jurisdictions are not ready to jump on board with that, so they'll have both exams formats available, meaning you'll be able to access multiple choice questions once they implement their new exam format. The BRC had multiple presentations conducted by the National Conference of Bar Examiners to evaluate whether or not we wanted to adopt that. The BRC ended up recommending to proceed independent of that and create a California bar exam. One of the concerns was that NCBE, their plan is not to have a remote version of that exam. If anything, I think their modality will be using test centers that people will go to. I think they're also exploring the ability to continue with this, each jurisdiction supplying a testing facility. I think that's also on the table, but not a remote modality. So I think that's kind of contributed to the BRC's decision. But so the BRC decided on a California-based California exam, independent of the next gen exam. Also that it should incorporate the CAPA recommendations. If you recall, CAPA recommendations included and spoke to the knowledge that was required for minimum competence, so knowledge areas, the skills, and the abilities. And so the goal of the new California exam is to adopt those. And it might reflect some of the same efforts that are being made by the National Conference of Bar Examiners. That is, with the things I mentioned yesterday, eliminating the high need for memorization, things that are more culturally fair, and maybe the same format of vignettes. This is something that we have to explore with exam developers and with experts on the best method of creating culturally fair questions that meet the minimum competence that we want and that are reflected in the CAPA. And so that's the recommendation that was made by the BRC that will be forwarded to the Supreme Court in the final report.
And it's also the case that the NCBE is going to phase out the multi-state, right? The multiple choice one. So at some point that's kind of the anchor for our scaling.
Okay.
So that's another problem we have to deal with.
Yes.
another question. If Alex and Ms. Lynn were to consider preparing, I guess, something similar to an amicus, what are some of the issues that we as members of the Committee of Bar Examiners should be aware of that they would like to present to the BRC?
Did you hear the question, Alex?
No, can you repeat that one more time?
Yes, if Alex and Esther are considering preparing some type of an amicus to present to the BRC, or that would represent the opinions or suggestions of the Committee of Bar Examiners, what specifically are or some of your suggestions that you would like us to consider and discuss?
I think that's really the purpose of today's discussion, is actually for the CBE to give us instructions on what you would like us to present to the BRC. At the end of the day, if there's a desire to present or attach a concurring or dissenting report for the full commission to review, it's certainly something that we can do. But I would defer to the chair, because I think this is something that we are still in this sort of talking about as far as what we would like to see. That's the general sentiment as far as what the BRC has decided in terms of motions, whether there are any, dissenting opinion as far as what BRC has already voted on, or things of that nature.
Alex, I think David is asking what concerns do you have?
Yes, because we're not there with you folks, apart from what was articulated by Ms. Nunez. What other issues have you and Esther faced or confronted that you believe that we should be concerned with, or that we should discuss at this time?
It's hard to say, because I think there are sort of two strong forces on the commission. One side sort of is very much in favor of a non-exam pathway, and then you have another force that is against it. And I think what's sort of missing there is a sort of a hybrid model that I personally believe would work, that would bring both groups together. A hybrid model in a sense that we would keep part of it with the keep part of the California components, but at the same time allows a model in which people can obtain supervisory practice that would also meet part of the requirement. And so the hybrid model in that sense, but I don't think anyone has ever presented that model before to the commission, but I feel like this is something that could be the point that would bring people together. But again, I would defer to the CB as far as what you believe to be the appropriate way to test minimum competency.
Didn't you also have some concerns, though, about, for instance, the exclusion of business organizations from the exam topics? And I think the public comment we received was also bemoaning the loss of, was it wills and trusts?
Yeah, it's business associations and wills and trust, correct. Both topics were out.
So there were 5 of the original 13, we're left with 8. So that's biz and wills and trust. Can we have the other 3 for the committee?
Are you looking? So which topics fell off the existing list?
From the CAPA requirements, I can pull them up.
Yeah. It'll take us a second. Somebody else have some other questions in the meantime?
I do, and I think it's kind of.
So the 8 topics are civil procedure, constitutional law, contracts, crim law, crim pro, evidence, real property, torts and administrative law, and procedure, meaning business associations, community property, professional responsibilities, remedies, wills and trust are going to be out. And Audrey can confirm that this is correct recitation of what I have in my notes.
I can't imagine the court would get rid of professional responsibility.
Well, what the premise for professional responsibility is that all the students, all applicants will have to take NPRE, and so in many ways the commission believed that it was a redundant topic, right? You wouldn't want to test someone twice on the same subject, and so that the mindset was well, since everyone will have to take the NPRE, there's no reason to retest that subject again. But Amy and Audrey, do correct me if I'm mistaken.
No, that's correct.
Yeah, I don't think that logic has worked so far with.
Well, and I would also note that during the discussions in Kappa, and Robbie, you can chime in here, but during the discussions in Kappa, the question wasn't just what should or shouldn't be tested, but what needed to be tested as part of the bar exam, and were there other ways to test or teach, to have some course on things like professional responsibility that just wouldn't have to be part of the traditional bar exam, but there still could be some obligations to test it or have a course in it, to do other things to ensure that people possessed the knowledge and of that topic, because obviously nobody was suggesting that that wasn't an important topic to have. And again, just to be crystal clear, what the BRC chose to recommend preliminarily are the same knowledge, skills, and abilities that were recommended by the Kappa working group that Robbie had served on as a representative of this group.
Bethany?
Yeah, this is I'm just trying to get a clarification. The discussion about the alternate bar is separate from the reciprocity issue. Is that right?
You mean the alternative pathway?
Yes.
Yes.
Okay. And so regarding reciprocity, I think Audrey had said that the commission had recommended to the court that they created a time deadline.
Recommended that they look at how many years of practice someone would need to have in their jurisdiction before becoming licensed here via reciprocity.
Okay. Did they have a preliminary suggestion, or were there any discussions about the time frame that the commission thought was appropriate?
Yes.
Yeah.
So what we looked at is how other jurisdictions are handling reciprocity or admission on motion, and looked at the average range, and it's somewhere between 5 of the past 7 years is one of the most common policies at jurisdictions. That is, you have to have actively practiced in 5 of the past 7 years. I think also I can look up the next most common practice, but that is one that is currently applies across the state, across the country.
Okay, yeah, and I think the other one is like 10 consecutive years or something in your other jurisdiction. And so I continue with the reciprocity. So I know that there's, like Alex was saying, 2 factions. That's mainly with the alternative pathway and not with the reciprocity issue. Is that correct?
So the BRC was asked to explore reciprocity for both of those pathways. We didn't explore reciprocity in a non-exam pathway because a non-exam pathway recommendation did not advance. So, so let's say a non-exam pathway had, I think the question would be, how do we handle, like if it was a experiential training or a supervised model that, like we have now, supervised practice model, what would that mean for applicants coming in from out of state or out of the country? Would they be eligible for that? And we did not have to explore that, given that there wasn't a recommendation for supervised practice or for a bar exam alternative licensing pathway.
The pathways we talked about were California law school specific, that the ones that we didn't come to consensus on. We're talking about California, but again, we didn't have consensus. So.
Can I follow up to that? Are we not, as the CBE, going to explore the possibility of reciprocity, as we mentioned yesterday? So that'll be our responsibility, correct?
Yes, because the recommendation to the court is to explore that pathway, but I think we could look at the specifics, such as what Bethany was raising here, which the timing recommendation. Do we want to recommend, how much experience somebody needs to before they lead to reciprocity?
And I think that is something that should be explored by this committee, because it's pretty much our responsibility, or at least something that, go ahead.
No, and that's all I was just trying to get clarity on, because I know we were talking yesterday about what kind of policies and things do we want to work on, and I am personally extremely in favor of California. We need a reciprocity. The other states have it. We've been discussing access to justice. And right now I can think of 25 people that are California natives practicing in other states. They couldn't pass the bar, but they've been practicing for like a decade plus, but we don't have reciprocity. And so they want to come home, but they can't. They work at, legal aids and nonprofits. And I think that our reciprocity is another avenue to really expand access to justice, and that we can get more minority and more women practicing attorneys that, have the ability and are practicing successfully in other states to come back home and do so here. So I was just trying to ascertain whether or not the issues with the alternative pathway, or what was the issue with reciprocity, if that was something that was being addressed, just solely reciprocity, not related to, like the alternative pathway, I guess. But that's all.
Mr. Chair, if I might note, that was absolutely, Bethany, one of the topics that that we had thought that this committee would like to tackle, should want to tackle as one of the big policy areas, to proactively step in and not just wait for the Supreme Court to ask you a specific question about it, but rather to develop a policy recommendation on reciprocity, years, how it would work, et cetera, et cetera. And so that'll be part of when we come back in January with a list of policy ideas. It sounds like there's support around at least part of the table for that being on that list. And so that'll be on that list for the committee to consider.
I do have that motion now that describes all the CAPA topics. Sorry, it took me a while to find it in our folders about the blue ribbon, if you want to see what the motion was from earlier. This was from the April 6th meeting. It also had the CAPA's recommendations on skills.
And so then I guess I have a question for Robbie and Alex. Robbie, because this is coming from CAPA. What was the rationale for deleting some, real world, high volume topics like wills and trusts and community property?
This is Robbie. One of the things that we miss when we at the Committee of Bar Examiners talk about these things is we miss out on what was a very spirited discussion over several meetings about all of these issues. So which subjects to remove from the bar exam was a year in discussing, and with a lot of data from our surveys that were sent to new attorneys throughout the state. And I want to, and believe me, Paul and CBE members, there were advocates for every single subject that has been removed. But the idea at the outset was there was a perception, I think a legitimate one, that there were too many subjects on the bar exam. There were 13, and we needed to somehow do our minimum competence issue spotting, analysis testing on a more limited number of subjects for the bar exam so that it was less of a memorization test. So the idea was, as Donna said, that some of these subjects that we were removing, we weren't removing from learning about them. We were just removing them from the bar exam with the idea that perhaps there might be a law school requirement enacted that this class or that class, there would be a class required in that, or a class to take online before you receive your license. But again, we're looking at how to make a fair bar exam that gets our goal across, minimum confidence, without overly relying on memorization. So that Paul, the topics that you're concerned about, gosh, corporations and wills and trusts, the CAPA committee was 30 judges and lawyers and law school deans, and everyone had an interest in their particular area of expertise. So I want to assure you, was not pulling numbers out of a hat. I think it was, over the course of an entire year with the data from new and 1 to 5 year practicing lawyers on the subjects that they felt they needed some expertise in to hit the ground running. And again, this was the majority. So, Donna, I don't know if there's anything you want to add to that, but I think that's how we got where we are, what you see on the screen right now.
Yeah, so I would just say, and I may get these wrong, and if I do, Amy, I know has them. But the survey data that was looked at was also looking at sort of those people who supervise those new attorneys, and looking at sort of the frequency. And there were a couple of categories, but the frequency for which the subject or the skill was required, the criticality for the impact if you sort of didn't have sort of the full information that you needed, and I think there was one other factor, but there were a variety of ways that they sliced and diced the data to look at which ones are most frequently used by entry-level lawyers, which ones have a high criticality, huge impact if you get something wrong. And again, that's a third factor that I can't think of right now, but it's detailed very expressly in the CAPA report that really analyzed, looking at these different dimensions, which questions made sense that we absolutely needed to test on the bar exam and which ones didn't we. Now, I would say that there are certain things that when you looked at the data strictly, I think, for example, constitutional law, came out sort of lower on the scale, and the determination was, well, constitutional law is so fundamental to everything else that we have to continue to test it, even though if you look strictly at the numbers, it didn't come in the top 10.
I just wanted to add one quick thing. So the items were rated on 3 things. They were on frequency, that is how often attorneys practice in the specific area, criticality, the potential harm if attorneys lack that proficiency, and performance expectation, that is whether that performance is expected of entry levels or considered appropriate for more experienced attorneys. So those were the 3 factors that created the rating scales on for each of those items.
And if I could just add one more thing, my concern about the CBE making a formal recommendation for the Blue Ribbon Committee is this. I have a lot of faith in Alex. He's at every meeting. He listens to what we have to say, and he takes that with him to the committee meeting, to the BRC meeting. That's why we chose him. If we make our own statement, we miss out on the give and take that is the very nature of the BRC. Alex is hearing things from people that like the hybrid approach. I agree. I think most of us on the CBE do, but there's going to be a lot of discussion that maybe this works, maybe that works. And then our recommendations old news because some new things have come in. And I think that when the CBE selects representatives to represent us at another committee, we need to trust them. And I do, I think we all do, trust them to take what they get from our CBE meetings and bring that to the table with them as our representative. I don't want to tie Alex's hands with a formal recommendation that there may be a speaker at the next BRC meeting and she will have some very interesting things to say about another method that hadn't been considered. And Alex knows where we stand and he takes the temperature of the room and listens to our thoughts. And that's what he does for the CBE. I know at CAPA, I presented a summary at the CBE meetings, but I'll tell you at the next CAPA meeting, there'd be a dozen things that we had not discussed. And what I did was I brought what we bring to the table every meeting at the CBE to that meeting. So Don, I don't know if you have a different view, but I feel like we need to let our representatives represent us and go from there.
Mr. Chair, if I, sorry, Don, go ahead.
So I was just going to
Robbie,
say,
I couldn't, go ahead, Donna.
I was just going to say that I offered up this option because we welcome the to use Paul words, concurrence or dissent, the input of all of the committee members. We will certainly it wouldn't surprise me if there was a concurring or dissenting report that ultimately goes with what's submitted to the board from one or more committee members. And so this was an opportunity, provided an opportunity for Alex and Esther as members of CBE, if the will of the CBE, as discussed today in terms of what you think should be the recommendations, differs from what ultimately is put out in the report, it would be a way for Alex and Esther as representatives of the CBE on the Blue Ribbon Commission to say, here we are speaking as representatives of the committee, and this is the position that the committee holds. So I don't think there's any problem with it at all, and I do want to make sure that the CBE has their voice heard in whatever way you think it is most helpful to have that voice heard, whether it's in the voice of Alex and Esther at the meetings expressing what you say here, and then whatever the vote is, or if it's having a concurring or dissenting report, depending on the outcome of what the commission wants to do. That's an entirely valid option as well. I just want to make sure that the committee has the ability to express its opinion and feel very confident that its opinion is being heard and taken into consideration.
Robbie, I couldn't disagree with you more. The point I was trying to make yesterday was, first of all, we didn't, while I have respect for Alex and Esther, and I have no doubt that they're going to represent our interests, we didn't pick them. So that they applied to the Supreme Court, who chose the members of the committee, the commission rather. But the point I was trying to make yesterday is that when people are out serving in these roles to represent us, we don't just send them forward and say, go do good, and try to figure out from what we said at meetings what we mean. You should come back to us, tell us what's going on. If we have concerns or comments, hear them, and then, and it's a process, it's an ongoing process. As the commission does its work, they'll hear new things and they come back to us and report, and we give them feedback. But they ultimately decide what to say on our behalf, but it should be informed with our thoughts that are delivered to them along the way. And that's the same way I personally feel about subcommittee chairs and vice chairs. It's not their job to influence or to determine the recommendations that the decisions we ultimately make. It's a job to make sure that staff's product provides the information we need in order to be able to make an informed decision. David?
Alex, by the way, I have the utmost trust and confidence in your abilities, but we've got two members here that are new to the board. Can you just briefly describe the hybrid model that you addressed earlier today?
Yeah, that's fine. Mr. Chair, before I jump onto that topic, I wanted to address that issue on business association. I do want to raise the issue that I raised that concern with the commission earlier this year about leaving out business associations. And one of the things I talked about was the data in the CAPA report, where the frequency and the criticality as well as reliability data actually shows business business associations as being much higher than civil procedure and con law. But despite that, the data, showing the contrary, the Kappa group just decided to leave out business associations. I made that very clear to the commission. But again, the commission just didn't believe it was a critical topic, and so it was voted out. So hopefully that addresses the concern. I did voice that concern with the commission. So it was talked about, it was debated, it just didn't go the way that you wanted. So with that, let me address the second question. The hybrid model that I had in mind originally was to keep the California essay components. That's sort of the fundamental part of the bar exam, but also, for the longest time now, we have had the MBE portion, but what I have in mind is to replace the MBE portion with a hybrid model where we remove MBE entirely and replace that with part of the supervisory practice. So now you have a hybrid model where you have, on the one hand, applicants being able to apply and receive supervisory hours and complete their capstone portfolio. And on the other hand, they also would be able to prove to us that they are aware and understand the California law through the essay portion of the exam. And so that's sort of the hybrid model that I have in mind, which the commission just hasn't really talked about this model, but it's something that, if the CB is interested, I would certainly present that model to the commission. So that's sort of an idea that I had.
Thank you.
Okay, anyone else? Okay, Dolores?
And this is for Alex. Alex, judging by the motion that we saw on the screen a little bit, your commission did act by motions rather than consensus?
Correct.
So do we know how you and Esther voted on the issue of the either or of a bar exam or no bar exam? Is that a
yeah,
Oh,
yeah,
it's all
on
recorded in the public minutes.
right.
probably is in the public?
Yeah.
Okay, then I can ask you.
Yeah, so we voted no on the non-exam pathway, and we voted yes on the exam pathway.
Thank you.
Alex, you voted yes on the adopting the Kappa recommendations for skills and knowledge areas on the bar exam pathway.
Thank you.
Okay, but as far as the non-exam pathway, where did you and Esther stand? In favor of it or not?
No.
So you were not in favor of it?
Right.
And was that because of the way it was described, or are you just fundamentally against any kind of option?
I wasn't fundamental against anything. I believe if you remember in the past couple of meetings, we came back and tried to receive feedback and comments from the committee. And so that was the sentiment that was received, that there was a strong belief for the bar exam. And so we voted sort of inconsistent with the sentiment that we received from the CBE.
Okay.
And of course, Paul, you and I have spoken on a number of occasions. And also when Alex Owens was still the chair, he certainly have given me his feedback about his position as well as yours. And so I took those feedback and voted in accordance with those positions.
Right. So maybe we should talk a little bit more about the non-exam pathway, because my understanding is that I mean, this is a judgment of mine, but it's just not very well defined. And that was the basis of my concerns. Many important aspects would be left to be designed later after this thing was set in motion, such as how are we going to objectively or with consistency measure whether people have succeeded in the supervised practice and succeeded to demonstrate that they have the skills to become a lawyer. There was talk about just, I guess one level is similar to the PLL pathway program, where the supervisor just says that, yes, they are, in my view, they are qualified and they should be admitted. That makes me nervous, certainly, because that's leaving it to the multitude of supervisors that are, attorneys that are out there that are going to be making these decisions. In a world where elementary schools promote students without giving them all the skills they were supposed to high schools do the same to the colleges are doing the same thing to the law schools, and maybe the law schools are also doing that in some cases. I think we need a gatekeeper that is going to, take a serious, unbiased look and not just be optimistic and hopeful that whatever deficiencies somebody might have, they're going to resolve down the road after they've been admitted to the bar. Another approach is to have what Alex referred to as a capstone. It's kind of like a project where they would write a project, and that would be graded. The question is, how do you determine that it was their own work that they're presenting to you, or not the work of someone else, or they were helped along by a consultant or something like that. The way many our high school students of means, get help with their college applications. How do we deal with that? And then we have the whole problem of that. If we have a grading system for that, that's a whole nother team of graders, a whole nother process. And with our budgetary challenges, let's call them, are we in a position to be able to do all that? So those are, I'm not fundamentally opposed to the pathway, but I am opposed to sending it on its way without addressing all those issues and putting us in the spot of having to resolve all of them, probably, with our hair on fire because there's a perceived deadline. I just don't think that is likely to turn out well.
Just a point of clarification, because I prepared many of the presentations for the Blue Ribbon Commission. We looked at the Ontario model in Canada and several other Canadian provinces that, along with that articling, which is what they call supervised practice, in Ontario there are 2 exams. They're open book exams, but they have those along with the articling. And then several provinces use a preparation readiness program where they have online modules, and then they have an in-person capstone where they do workshops in person. So a capstone doesn't necessarily have to mean a written product that, again, you're concerned about the security of that. And a bar exam alternative doesn't have to mean that there is no exam at all, because there is precedent in other jurisdictions in Canada for having exams associated with their supervised practice program. Also, to Alex's point about a hybrid model, in Delaware, they have a 5-month clerkship requirement along with passage of the bar exam to become licensed. So that's something, again, like we were talking about yesterday, in terms of looking at trends in licensing. Should we have Delaware present and, kind of learn from other states about what they do with their admission requirements?
Yeah, an aspect of the supervised practice to also consider is access to that. If we have all of a sudden a lot of people who need to obtain those positions, will they be available? Will they be as available to people of limited means? Who will win the competition for those slots? All questions that remain open questions, and I think it's important to resolve those before we launch something that fall on its face.
So if I may suggest, couple of points. One, I very much understand and appreciate the cost concern. I want to make sure, however, that we separate that determination from the policy determination. I think that a policy determination should be made on whether something like that is an appropriate path to adopt. If so, then a recommendation can be figure out if there's a way to afford to do it. But I really don't want us to foreclose talking about something because we predetermine that it can't be currently afforded. The other thing that I would note is, as we talked about yesterday, with the recommendations that the Supreme Court now has in their hands to extend the provisional licensure program, one of those recommendations included extending the original program for 3 years and directing the state bar by the end of 2023 to provide a recommendation to the Supreme Court on a supervised pathway pilot for the small cohort of individuals who are still in the program. That would allow the committee to sort of develop the portfolio reviews, the number of hours, the coming up with, if there's an assessment, what are the components of a supervised pathway? So because there is a possibility, again, I have no insight into what option the court may choose, but because there is a possibility that the court might direct the state bar with the committee of bar examiners to develop that supervised pathway pilot project, I'd probably recommend that the committee not sort of take a strong position one way or the other today on whether you support such a pathway. But rather, if the court directs that we develop one, use that opportunity to really test what might work in a permanent, bigger supervised pathway. That's the great part about the pilot concept, I think, is that with a small cohort, it gives us a real ability to closely monitor and figure out the components of what a supervised practice pathway would have to be in order for it to be successful, how you'd need to grade it. Because, and to that point, I think ultimately all the recommendations or possibilities that the Blue Ribbon Commission was looking at required the regulator to do the evaluation and the grading, and it was not just based on the supervisor's input. But figuring out what that looks like, and if you need, as you suggested, a totally different cohort of graders, what that would, how we would be able to do that. I think it provides an interesting opportunity to figure out if that's a way to go. And so we'll see what ultimately the Supreme Court recommends on that. But in the meantime, I just wanted to leave you with those thoughts.
I agree with Donna 100% on that. I think that we have an opportunity with what we discussed yesterday and put it in the hands of the Supreme Court. If they agree, then we begin establishing our metrics with respect to the new program. So thank you for those comments, Donna.
Yeah, I agree with what David said. Like, what we've been talking about is extremely interesting. It's just, we don't even have any real information in front of us right now to think about these issues to make a really informed decision. Well, I will speak for myself. I don't feel like I have enough information. Like, the topics that Audrey just brought up are very intriguing, and I would like to look more into those because I think that would inform my opinion about, an alternative pathway or a non-exam way or, the supervised practice. But we're just listening to the report from Alex and Esther. And I do trust them at the commission to, relay back information. But I feel like, at this point, how would we really make an evaluation to answer some of the questions you raised, Paul, because we don't have anything really to work from in front of us.
Well, no, and I understand that. What this is an opportunity for those of us, like obviously me, who have some concerns to make sure that they're heard. And then they'll have to take all that in and apply it when they see the draft of the final report in early January.
Will we get a copy of the draft just to look at? Or?
I'm thinking that when it comes out, we could schedule another discussion on our January meeting, for instance. Depending on how much time they give for public comment, do you have any idea, Audrey or Donna, when the deadline's going to be?
I don't, I mean, I think it's going to be fairly significant, I would imagine.
But the earliest it might be is the end of March.
I'd need to sit down and do the math. But I would imagine we're probably looking at 90 days.
Okay, so, but we can certainly present it, pass it out in January, and we can have we'll have a placeholder agenda item for it in January, and if it looks like we have extra time, then we can put it over to our March meeting, have it again. But because this is one of the most important things that's going on regarding our area of well, expertise, and also the work that we are in charge of overseeing and providing policy guidance regarding. So I think we want to keep as close an eye on this as we can. Kareem and then Dolores.
Yes, so
Michael.
Definitely kudos to the spirited conversation, everyone's input. Thank you, staff, for your feedback. I'm one of those people, I'm a public member. I come from an underrepresented community. I say that very often. It's for the fact that I think from a policy perspective, there's different solutions for different type of impacts that we're seeing. You're seeing a lot of credentialing and licensing agencies change their methods. A lot of the reason why is because the next generation of leaders and learners are just learning at a different level with a different type of value system. And so we saw that during the pandemic, when we saw all the students that were essentially asking us to get rid of the bar exam. I know that's an extreme approach, but what I took from it was like, there's obviously something that people are not agreeing with the system that's been established for however long. In the evaluation of other systems, you saw that even there's states where it's just an exam and then you become an authorized lawyer. So I guess from our perspective, a non-exam pathway is something that could potentially work. And I say that when we look at the data from the PLP program, while I did require a passage of the bar, we saw an 80% passage rate or approval rate of people becoming lawyers. And from the data, and I really thank Amy for putting that together at one of our meetings, we saw people of color really getting a fair opportunity in those circumstances. And I could tell you, I come from an under-resourced community, and so people like my neighbors don't have the thousands of dollars to get bar prep, to go to the fanciest schools. And so what are other methods? I mean, I love that there's an idea of a pilot program, but what are other methods that we're looking at? How are we innovative in our policy to achieve equity and diversity, access, inclusion? You know, a lot of the times in the government space, we say these things, but we don't really put ourselves in the places of people that have been oppressed and historically impacted, and say, how do we alleviate some of these issues? And so in my area, we're under-resourced with judges. We don't have a good lawyer to person ratio. And so we have a lot of justice issues, and it results in policy issues such as like immigration, homelessness. And so I know while we can't solve that overnight, I think in this environment, we have an opportunity to really create some programs and some pilot opportunities to say, hey, we're making the steps to address this, and we're not just rubber stamping what's been done over time. And I think that's hopefully a perspective I could bring, because I'm tired of doing the same thing over and over and getting the same results. It's like, what are we really trying to do here? Are we here just to ensure the bar stays where it's at, or are we really trying to make real meaningful changes? And when Leah came the other day, she put some budget items according to diversity actions that she wishes to take. But it's like, here we are today to actually have this discussion. I love that we're having this. I have nothing but respect for Alex and Esther, and I know their positions as well, and I respectfully agree and disagree sometimes. But I think we have a meaningful opportunity to really make our position known. We don't have the data, and I agree, but I think we have enough knowledge and information here to kind of give some element of direction for a later meeting to say, hey, let's start having these real meaty discussions. And what we're seeing is not through the Blue Ribbon Commission and alternative pathway, but we're seeing from another angle, the Board of Trustees have this conversation. So obviously not everybody's on the same page, but everyone's trying to get to the same place. It's just the how. you know? And I think that's what we're discussing today, the how, because we know the why.
Let me ask you about the alternative or the new way of learning that you referred to. You know, I'm obviously an older person, and is there some place or somebody who could teach us and me about that?
Yeah, I could tell you the entire state is moving towards apprenticeship programs. And I know it's a little bit different than licensure, but you're having apprenticeship programs being the next wave of like utility workers. People that are powering our communities are literally getting jobs with 6-month certifications and literally having our life in their hands through apprenticeship and pre-registered apprenticeship programs. So I'll look into my network and see what could be the most relative and impactful. But that's the way the state is really moving towards training the next workforce.
Okay, so that's job training as
Yeah.
opposed to general education.
It's a both, because it requires general education and job training. So it's the pre-registered to an apprenticeship program. So it's like
Okay.
a 3-4 year type of
And-
program.
And is that more, so it's more at the community college level, probably?
Yeah.
Yeah, okay. Yeah, I'm curious to learn about that, because it's, you know, it's, well, it's harder for me to learn that in my daily life. But I appreciate your thought, and I would like to learn more. Who was next? It was Dolores, I think, then Dr. Cow, and then Bethany.
I just
And
want to
Ashley.
add my thanks to Alex and to his cohort for being on this committee and representing the interests of this committee very, very well. I didn't want to leave it as though we were putting them on the spot, but we really appreciate your work. I, for one, agree with you wholeheartedly, Alex, that we need somewhere in between type program rather than an either or. So thank you.
Dr. Cow was next, yes.
You know, I just wanted to make a comment. First of all, I think that as a public member, our other hat that we wear is public protection as well. And so what I want to bring up is that the medical licensing system is equally a regulated system, just as the legal system is. And, you know, in our licensing process, we also have a, I wouldn't say a non-exam pathway, but we have both exams and preceptorships. One of the points that I do want to bring up with this preceptorship, and this is something that I think as a CBE committee, we have to be cognizant of, is that the preceptorship opens up a lot of potential regulatory issues. It opens up the fact that we're going to have to think about how to accredit the preceptors, not as individuals, because what, Paul, you alluded to is that preceptors are going to be fighting for warm bodies to help do the work, number one. Number two is that, and Kareem's point is highly taken care of, I mean, highly regarded, is that the students, people potentially wanting to become licensed, are going to be not as much attracted to areas that they feel that it may not be beneficial for their long-term job prospects. So certain affluent communities may have higher number of applicants than maybe what Kareem's point is not as affluent communities will not be able to attract the potential students or trying to get their license. So in the medical system, we have a huge issue with accreditation from an organizational level to individual preceptors. And that is a system that will bring equal amount of potential work and problems like we are having with law school accreditation. Except this time it's going to be accrediting preceptors, and individual preceptors are going to vary on their background, what their motivation is for being involved in this, and also how are we as a regulatory body going to be able to come up with rules for that. So I just want to kind of bring that up, is that we have equally similar issues on the medical system side.
You use the term preceptor. Could you say a little bit more about what that role is, where they fit in the process of a medical student becoming a doctor?
So the medical system, we are more envious of the legal system in the standpoint that when we finish medical school, we get an empty degree called an MD, which allows us to do nothing. We are not licensed. We are not allowed to practice. And so in order to become licensed, we have to do additional training, sort of, what Kareem alluded to is an apprenticeship. Our apprenticeships can be, for instance, if you want to become a primary care physician, you have to do a 3-year apprenticeship. If you want to be a neurosurgeon, you have to do a 10-year apprenticeship. And during that apprenticeship, you have to take exams to pass each year moving forward, or potentially several years moving forward, number one. Number two, your preceptor is sort of what this provisional licensing program is about, which is you are under a mentor, but that mentor actually has to be accredited. And typically, mentors are accredited not as individuals, but they're accredited through the organizational body that agrees to being able to take potential licensees and make sure that they meet their criteria so that they can become licensed by the medical board itself. And so a preceptor is an individual who meets all the medical legal requirements, both from a medical credentialing standpoint and also a legal credentialing standpoint, to be able to take on a apprentice or what we call postgraduate training, to be able to do that. So that is something that's been a part of the medical system from its very existence. And because of that, I just do want to caution that with a non-exam pathway, which is a great idea to move forward, that we bring in more justice, bring in to help more minorities, skin of color, but it does bring up these other issues that we have to be attuned to because of the fact that it's something that we haven't really dealt with on the legal side.
So having survived it, you consider it to not be a experience you would recommend for everyone?
So one of the things that, and Donna brought up is, we should never bring in financial considerations into policymaking. But when, on the medical side, we are in a huge amount of debt when we graduate medical school, just like law school. But the difference is that in our postgraduate training, we are paid essentially minimum wage for 10 years. I'm actually by training a clinical cardiac electrophysiologist. So I'm the specialist of the cardiologist. And that is 8 years of getting paid minimum wage post-medical school. So that is something else that I want to bring up, is that the amount of debt that potentially students come out with just accrues. And so that is something that we should also be cognizant about, is that a lot of times we worry about making sure that we have students pass, for instance, the bar exam, so we can have a increased number of attorneys and judges because of the fact that the system is overloaded. But from a student standpoint, the amount of debt is going to be raised significantly. Number two is there's going to be an accreditation issue that we're going to have to deal with, and that's a whole process. So, to your point is that I think that this is something that maybe if we can try to learn from the medical board and what they do, to maybe not copy, because there's a lot of missteps on the medical regulations standpoint as well, but how do we improve upon the systems that are in place?
So it sounds like you're making an argument that we should not eliminate the bar exam and force everyone to go through an alternate pathway. They should have the choice.
I just, I don't know if I'm making a binary argument, yes or no. I think I just wanted to bring up the experience of both potentially the positives and the negatives.
Okay, well, that's what I took from it. I won't put words in your mouth. I think Bethany was next, and then Ashley. Okay.
I will say that I think, more in line with how Kareem is thinking. I am a big proponent of a non-exam or hybrid pathway. I don't think that the bar exam is working in its current state to even test minimum competence. And I think that a lot of my generation of attorneys shares that sentiment. To address, I think, some of your concerns, just from the practical standpoint, students getting jobs and removing the bar as a precursor would flood the market. I will say that primarily a majority of students are already getting their jobs prior to taking the bar. I had my job lined up prior to taking the bar, and it was just under the premise that sometimes they require that you pass the bar or you lose your job, or you can not pass the bar and then they'll keep you on. So there are already positions where a number of our students are already getting employed into positions without having a bar exam passed. So those jobs exist and there is a need. So I wouldn't worry too much about the flooding of the system. I think we also should, if we're considering, a provisional licensing program with the oversight of a practicing attorney, that we should also, if we do believe in the minimum competency that is ordained from the bar, trust that the people that are in charge of then approving whether a student is prepared to practice, that they already have those minimum competences. They've passed our standards for minimum competences by passing the bar. So they should be able to be trusted generally, so long as, obviously some conditions are met, to impose that same condition onto a trainee. So I think that there's value in that. I will say that I was very interested in the Canadian approach that Audrey was mentioning. I think that's a really interesting idea in the way that they do their functioning. And I think that, and I believe in past, we have had, and maybe not the CBE specifically, but in the Blue Ribbon Commission at least, that there have been listening sessions, and especially around the 2020 grads, where they were being heard by the Board of Trustees specifically about their concerns that if we were to move forward with any kind of provisional licensure or a hybrid approach to any kind of alternative to the bar, that I think those listening sessions are going to be really essential, especially from attorneys like myself within the first 1 to 3 years, and I would say even 1 to 5 year range of practice, because those are the attorneys that would have either benefited or had detriment from a non-exam pathway and would have the most relevant experience to speak on the issues that, I think a lot of our board members may be missing that perspective, because it has been a while since the bar exam was taken, or there are public members who haven't taken the bar at all. And so I think, one, there's ways, and I support those ways and finding those ways. And two, if we can explore the idea of listening sessions, even prior to a decision being made about whether or not we are advancing a provisional licensure program or whatever it comes, I think listening sessions at all points are still going to be essential, and having a targeted day where we say, because I will say I don't think that people are chomping at the bit to come and listen to a CBE meeting. But if we're talking about a listening session where we're talking specifically about what a provisional licensure program looks like and the pros and cons, I think a lot of our new licensees and even students would be interested in attending that meeting, and that then we might have an issue with that 2-hour public comment problem.
Well, we have had forums. Let's see. Let me just throw out one more thought. There's an assumption that if we allow more lawyers to be admitted, if we reduce the barriers, that more people especially disadvantaged people, will be served. And I question that, and I would like people to address my concerns. After all, there are the occasional people who want to become a lawyer for altruistic reasons, but everybody still has to eat, feed, clothe themselves, transport themselves to court, and I wonder if we're not missing the economic problem, financing these public interest jobs, so that people will be willing to take them because they can make a living. It's one thing to have lots of lawyers, but if they have to work somewhere else in some other profession because that's the only job they can get, I don't think. In other words, I don't think enlarging the pipeline is the complete answer to the problem, and I do think we ignore the other part. But it is one of the items I have on my list to try to see if we can get some, for instance, somebody from the Access to Justice Commission to come and talk with us about that and what they've found. Ashley?
And I will say that even with the 2020 grads, from what I've heard, is that they're sort of related to your comment, is that there were concerns and issues with the way law firms were paying those provisionally licensed attorneys, whether they were being paid at the same rate as an attorney or whether they were being paid at the same rate of a post-bar who hadn't yet passed the bar. So I think that is something that we also should consider about when we're considering access to justice, that, I think, yes, many of us do go into the field for altruistic reasons, but also I would say an equal number of us also come from low-income backgrounds. And we do need that financial substance to support ourselves and our families who are counting on us as first-generation graduates to also bring in income. And if we are looking at a provisional licensure program, we do also have to consider that concern of what are firms paying, what is the going rate when there are attorneys who may look down on a system that they believe is less than the bar exam that they had to take, that they had to do to get provisional or to get licensed.
And I don't know that we have the power to certainly to regulate that, and
I don't think so.
and we do have to recognize that providing that supervised existence may add to the law firm's costs, so they may have to take it out. They have to take it out of somebody, and so it's very complicated. That's, I guess, the point. Donna.
Yeah, thank you. So I just actually want to address 2 points, one that Ashley just made, and then one, Paul, that you were making. Please know that there are a lot of other efforts that are going on outside of the Committee of Bar Examiners and the Office of Admissions, looking at access to justice and looking at recruitment and retention for legal aid. So for example, last year, the bar, in partnership with the Legal Aid Association of California, as well as the Access to Justice Commission, proposed and got put into the budget, but ultimately it got blue penciled, what was an $11 million a year for 5 years loan repayment assistance program to address recruitment and retention issues in legal aid. So this is a big commitment of the bar to be looking at this. It's been part of our goals, and we're working closely with the Access to Justice Commission and Legal Aid Association of California in coming up with addressing some of these issues. Some of the interestingly, we met with the legal aid community just a couple of weeks ago, talking about changes to the registered legal aid attorney program, also as a way to help the legal aid offices retain legal aid attorneys, and what we could do to make it easier for them to have these registered legal aid attorneys, and what some of the barriers our current rules pose for that. And so we're looking at that as part of the special admissions rule revisions that Kathy Scher talked to you about yesterday. With regard to Ashley's point, oh, Ashley, give me a very 2-second
The,
reminder.
pay scales.
Pay scales, yes. I would ask you to take a look at the data, and I think it's something that if we are constructing a longer term program, we look at the data that was collected. We asked specific questions in the survey to provisionally licensed lawyers and to their supervisors about how they were paid. We asked rate, but we also asked if they were paid. Some of the categories Ashley said. The same as lawyers their year who were licensed, the same as postgrads who weren't licensed, the same as paralegals. And we asked some questions about that. So that's some data that we can look at and think about if we are crafting some sort of more permanent program that involves supervision, having some commitment potentially on the part of those who would agree to supervise, to pay at a certain rate or whatever. But I think the data will be informative in just understanding what those who responded to the survey indicated they as the employer paid or they as the provisionally licensed lawyer were paid.
Thank you. Was there some other comment? No. Okay. Well, you know, I think this is a continuing exercise. I hope you found it somewhat valuable today to at least start to tee up the issues, and we will bring it back in January, hopefully with a copy of the report that's issued by the commission. And if for some reason it's not ready by then, maybe then we will just table the discussion until our next meeting. But we'll keep talking about this until unless somebody thinks we should just quit at this point, wants to make that argument. I think, in my view, this is a continuing discussion that we should continue. Any thoughts about that? Okay. Alex, did you have any specific questions for us, or are you satisfied with the feedback that you've received?
I'm very satisfied. I like this, fulsome discussion by everyone. Literally, this is an important issue that needs to be thought about, discussed, and debated. So I appreciate giving me the feedback.
Okay, thanks. Okay, there was no motion intended with this item. So before we, and our question selection for the attorney members is scheduled to begin at 1 p.m.
We could possibly start sooner. I'm trying to talk to the EDGE team while we
okay.
can, but so.
Hold on a second then. Okay, it turns out we can start at noon with the EDGE team. And we're going to have sandwiches.
Yes, box lunch is coming at noon.
Okay, box lunches will be here then, so we can have a working lunch. But otherwise, for the public members, do we have any concerns about a quorum for the EDGE discussion?
A bit, but that's when we get to closed session, so we should close.
Okay.
Close open.
But we need those of you attorneys on the Zoom call to rejoin us for the closed session.
And you would have received a separate Zoom from Lisa Cummins, so maybe some thumbs up from the Zoom that they have. Yes, thank you, Donna. But Robbie, Judge Herman, hopefully Alex as well. Alex, you have the separate.
We're going to recess for the closed session, and then we'll come back after the closed session just into this open session simply to announce that we finished the closed session. But the public members do not have to stick around for that. Do we need a motion to recess?
We need a motion to recess.
We do? Okay, so first I would like a motion to recess until noon for the closed session. And I'm sorry?
The mic, oh,
Apologies. Is it possible to begin at 11:30 since we've got our Edge folks available?
I'm trying to figure that out with the.
We're checking with
Yeah.
them.
Okay.
I second David's 11:30 request.
One option would be to recess until 11:30, and if you don't have sufficient members at that time, continue the recess until noon.
Move to recess until 11:30.
I second that.
Okay, Torres and Peak, vote please.
Dr. Bolton? Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora?
yes.
Judge Guerra?
Yes.
Dolores Heisinger?
Yes.
Judge Herman?
Yes.
Larry Kaplan? Alex Lawrence?
Yes.
Esther Wynn? Bethany Peak?
Yes.
Ashley Silva Guzman?
Yes.
Vince Reyes?
Yes.
David Torres?
Yes.
Dr. Wilcoxon? And Paul Kramer?
Yes.
The motion passes.
Okay, so Caroline, can we go then directly into closed session at 11:30? Or do we have to come back into open to go into closed session? I'm sorry, Jean.
You should be able to, I mean, if you want to amend your motion right now to go right back to closed session, fine. You should go into closed, no, you guys should be fine.
Okay, I'll just
Sorry.
announce that we're
The
we're
Edge
going.
team needs to start at noon. Sorry, they are all not able to come back at 11:30 where they
Okay,
are.
so
in
we
San
have to start at
Francisco.
noon.
I'm sorry.
So I'm announcing now that we're in recess and we will come back at noon into a closed session. So the next time you'll hear from us on the recording of the open meeting is later in the afternoon when we return from the closed session. Thank you all.
Okay, see you at noon, everyone on Zoom.